The Commission on Elections extends the deadline for presidential aspirant Bongbong Marcos to respond to the petition to cancel his candidacy. Marcos has until November 22 to respond to the poll body. The legal counsel of one of the petitioners disagrees with the COMELEC's decision to grant the late dictator's son request. Let's go straight to the source of the story. We have the legal counsel of one of the petitioners, Attorney Theodore Te. Attorney Te, welcome to the source. Good to see you again.
Hi, Pinky. Good to see you. Thank you.
Okay. So let's start with this. A number of petitions have actually been filed to cancel the certificate of candidacy of BBM. And there was also a disqualification filed, I believe, the other day. Let's talk about the first petition to which you are the counsel. It was yesterday, no, Attorney Te, when I spoke to Attorney Vic Rodriguez, and that was the time he admitted that there was the second division granted the motion for extension of time to file a verified answer by the camp of BBM, to which I know you had opposed. You had a tweet about this even yesterday, which I based my premise on questioning Attorney Vic Rodriguez. So what happens now? It's official. There's been an extension and must be submitted by November 22.
Sorry, Pinky, there was some noise towards the end. I couldn't catch the last part.
Opo. What happens now? Because nagrant po yung extension to file the verified answer.
Yeah. As when we received the email of the COMELEC at about 2:53 p.m. Yesterday, we were surprised that the COMELEC granted the motion for extension, no, for many reasons. And so, just to answer your question directly, we have recourse to a motion for reconsideration under the COMELEC rules, and we will be filing that motion for reconsideration. We disagree with the order of the COMELEC granting the motion for extension.
So when will you file the MR?
Hopefully within the day. We have 5 days to file it, but hopefully within the day, considering it's already Friday.
Opo, exactly, Attorney Te. It's November 19, and I think the date to which they must file their verified answer is on November 22. So that's just about 3 days from now. It's on Monday.
Yes. And considering we only received it yesterday at about 2:53, and so we will be filing it within the day. One thing, Pinky, that we must say here, no? The motion for extension of the respondent actually referred to a period that had already lapsed. The period lapsed on the 16th. And so my first question when I saw the order of the COMELEC was, what were they extending? Because the period already ended. And so effectively, there was nothing to extend. So what do we make of this period? Is this a new period? And if it is a new period, what is the basis for granting the new period?
How important is that to be answered?
I think it is important in the sense that the COMELEC has, by its own rules, made the order to file answer inextendable. And this is not just one case that they're handling. They're handling many cancellation cases. And so, it is to their interest, the COMELEC's interest, in pursuance of its mandate to ensure credible, fair, clean elections, orderly elections, that they follow their own rules. And if they were to deviate from their own rules, then they should maybe at the very least provide a strong justification why they're making an exception. But in this case, the rule very clearly, their own rules very clearly state that in a cancellation case, there should be a non-extendable period of 5 days within which to file a verified answer. And that's the rule that applies to everyone. And so we were wondering, what was so special about this case?
So that's what I wanted to ask you, because at some point I did read an inextendable period. So pag sinabi pong inextendable, hindi po pwedeng i-extend. Yet a request was granted to extend and the request was granted. So does that mean that inextendable period is really not inextendable? Ganun ho ba yun?
That is also our question, Pinky, because as far as we understand the word, inextendable means there's nothing to extend, no? And therefore, when the COMELEC says we are granting an extension, is this an exception to this case? Meaning, will they grant the same to every other respondent? Because if this is an exception to this case, the question is, what makes this case so special that they would grant an exception to their own rule?
Could Attorney Te, could it be that there were other petitions filed?
No.
Kasi parang ang lumalabas, Attorney Vic was saying that he didn't use the word piecemeal, pero to that effect po yung sinasabi niya, padagdag ng padagdag. And they need enough time to answer those other added petitions to the cancellation of the COC.
That is the nature of proceedings at the COMELEC, Pinky. Based on the rules, as I understand it, petitions for cancellation, petitions for disqualification can be filed within the period provided. So in this case, this was a petition for cancellation, and each person who wishes to object to a particular candidacy can file. Now, is that the fault of the petitioners? No, because they are given that right to file, to oppose a candidacy. Now, is there any mechanism on the part of the COMELEC to ensure that related cases should be addressed together? Yes, there is a procedure for consolidation, but I must stress, there has been no order of consolidation here, and therefore the case referred to by the COMELEC in its order yesterday, referencing the case filed by Attorney Calleja on behalf of his clients, was not indicated in the notice itself. When the notice was filed, the instruction was to answer the allegations in this particular petition, not the petition of Attorney Calleja.
Yes, the first petition, to which you're the counsel. That's why I laid my premise on that. I think there are 3 for the cancellation of the COC, and there is 1, which is a different animal, which is a disqualification case. So, kumbaga, Attorney Te, I'm trying to understand the situation. May 3 cancellation of COC at merong isang DQ or disqualification dahil there was a period after which you can only file a cancellation of the certificate of candidacy, to which your group umabot po dun sa deadline na yan. Okay, so if they, and because they did extend the answer to the verified answer from the camp of BBM, does that necessarily mean that any other case in the future, any cancellation of COC, mapapayagan na po ng extendable period?
Yun Pinky ang implikasyon and which is why we will point that out in the motion for reconsideration, that there is a reason why the COMELEC made it inextendable, because there will be many cases that they will hear, and there must have been a specific reason why the rules of the COMELEC itself provides that in such proceedings it must be inextendable. Why? Because there is a need to determine immediately, without delay, yung viability of a candidacy. And so I would agree with what you said, Pinky, because if the COMELEC maintains this order, what is to prevent other respondents, in other cancellation cases, now to ask for the same treatment as this particular respondent? Which is why the question we asked was, what is so special about this case that they would grant an extension? And secondly, Pinky, I must say this. It isn't really an extension because, again, there was nothing to extend. The period ended on the 16th. The order came out on the 18th in the afternoon. So as of that point, it is actually legally incorrect to say there was something to extend. There was nothing to extend. Yes.
Because the period lapsed already.
Yes, the period lapsed already. And so this is effectively a new period. So so the question again is, what's so special about this case that a new period would be granted?
Sa Tagalog po ang tanong nyo, paano pa i-extend ang isang bagay na napasuna? Parang ganun
Oo. Hindi mo kayang buhayin yun Pasuna 16 pasuna siya That's why when we filed our opposition on the 17th, we said, walang verified answer Klaro yun, di ba? And therefore, the COMELEC could not revive the period. The legal treatment of that motion as of the 17th, without an order of the COMELEC, was that it was moot. It is a moot motion. And therefore, the COMELEC should have done what it usually does with moot matters, meaning dismiss it. deny it. No? Kasi
Okay.
tapos na, hindi na kayang buhayin eh.
All right. Attorney Te, we need to talk about also the basis of the cancellation of the certificate of candidacy by your group. There was something I read about this, which talks about judicial matter. That's what I want to find out after the break. This is The Source on CNN Philippines. Please stay tuned. You're watching The Source on CNN Philippines. I'm Pinky Webb. Our source today, Attorney Theodore Te. Attorney Te, there's one thing that came to mind now when you were discussing this with me. Dahil nga in-extend past doon sa deadline, could you at some point raise a technicality issue on this na pwede pong submitted na for resolution ito or something to that effect based on mere technicality?
Yes, Pinky, and I don't think it is a technicality. It is
Okay.
based on the COMELEC's own rules. No, in the COMELEC's own rules, it provides that if there is a failure to file a verified answer within the inextendable period, the only thing left to do is to proceed. No, the COMELEC will proceed because the respondent is barred from controverting the evidence and is also barred from submitting a memorandum. So effectively, wala na siyang parte doon sa kaso kasi hindi siya nag-file, no? And that is in the COMELEC's own rules. That was also reiterated in the notice and the summons. That is why our opposition to the motion for extension brought that up. We reminded the COMELEC,
I see.
this is your own rules. We're quoting your own rules. We're not making this up. Galing sa inyo ito. And therefore, because the period had already lapsed on the 16th, without any action taken by the COMELEC, there was nothing to revive. Factually and on record, there is no verified answer, and therefore
There's
the next
nothing to
logical
extend.
thing that should happen, there's nothing to extend. The next logical thing that should happen is for the COMELEC to follow its own rules and let the consequences happen.
All right. Let's talk about the basis regarding this cancellation of the COC. So again, we're talking about basically it's anchored on the conviction of former Senator of BBM in 1997 for failing to file his ITR from the years 1982 rather to 1985, 2, 3, 4, 5. That's 4 years, sir. How I understood this as a non-lawyer is that moral turpitude must be established. And how easy or how difficult is it to establish moral turpitude?
Pinky, ayokong pumasok sa merits of the case because again, we are anticipating if the order of the COMELEC is not recalled, we will be going to a preliminary conference, and I don't want to telegraph the strategy. But let me just siguro say that the petition for cancellation, as reflected in the petition itself, is based on the failure to state in the COC, the failure to state in the COC something that is material.
Yes, basically you're saying,
that is the ground. That is the ground.
I'm not sure if you're going to answer because I'm not sure if this will go into the merits again of the case. But are you talking about misrepresentation?
One, misrepresentation and failure to state a material fact.
So,
as pleaded in the petition, Pinky, there was an obligation on the respondent's part to state something affirmatively. There was also an obligation on his part to refrain from saying something. So dalawang bagay yun. Those are the basis for saying that the COC should be cancelled.
Yung pong tinatanong ko nga kung ano yung nakapaloob sa COC when one aspirant actually submits this first, of course, to the legal department before this is stamped. I'm not sure who I asked. Unfortunately, nakalimutan ko na po. Pero tinanong ko, is there anything in the COC that actually says, have you been convicted of any crime in the past? Because I know the answer to that I was told was there was no such thing. So again, leads me to my question, how could he have misrepresented himself if there was no such thing asked in the COC? Or I just could be wrong, sir.
I think it refers to item number 22 on the COC, Pinky. Have you ever been convicted, found liable for an offense which carries with it the accessory penalty of disqualification? Item 22 of the COC.
So nandun pala, sir.
Andun. It is there.
Okay.
The relevant question is whether the applicant for public office has been found liable for an offense which carries with it the penalty, the accessory penalty of perpetual disqualification to hold public office that has become final and executory.
Then let me cut you there. Perpetual disqualification, but that's the question, sir. Who says that his conviction on his non-filing of ITR is the basis for a perpetual disqualification? Yun po yun eh.
That has been pleaded in the petition, Pinky. Nakasaad yun sa petition namin. And again, we will leave it to the COMELEC to decide. But the narrative of the trial court cases and the elevation to the Court of Appeals on review is relevant in determining whether or not that fact actually exists.
Yeah.
Siguro ganun ko na lang sasabihin.
I know you can't say much because it's going into the merits of the case. I understand, sir. Kaya lang, kailangan ho, sa pagkaintindi ko, ma-establish yung moral turpitude also. Very quickly, I have 1 minute left. I wanted you to react on this. I hope you don't mind, Attorney. Ex-Justice, former Justice Alberto Agra in the Chiefs, I read the article. He said that this might be a judicial issue rather than a COMELEC matter. Just let me add, he said that there was a 2009 decision of the Supreme Court that said that non-filing of tax returns is a crime not considered moral turpitude, not considered moral turpitude. In the ruling, he goes on to say that the court made a distinction between the offenses of non-filing, fraudulent filing, and fake filing. The court, he said moral turpitude only pertains to fraudulent filing of ITR. Ang ibig sabihin, kailangan fraudulent filing para maging fraud to, fraudulent filing para magkaroon po ng kaso ng moral turpitude. Just a quick reaction to that, because that's supposed to be a ruling in 2009 by the Supreme Court.
Again, Pinky, ayokong pangunahan ng COMELEC, no? Because it depends on what the COMELEC will say. But I will agree that I think whatever the COMELEC will say about this particular petition, I think it is bound for judicial review. It is bound for the Supreme Court. Whichever side the COMELEC decides, no?
Yeah.
Aabot at aabot sa Supreme Court ito. And it depends on how the COMELEC will decide, no? Kung anong issues ang sasabihin ng COMELEC. So the point that was raised earlier may not even be the issue that will be decided by the Supreme Court. For example, if the COMELEC does not make that an issue. So to our mind, the ground is quite simple, quite straightforward. Material misrepresentation, that is the ground. And therefore, if the COMELEC agrees with us, then the respondent will probably go up. If the COMELEC does not agree with us, we will probably go up to the Supreme Court. Yeah. So he's correct in the sense that it will become a judicial issue eventually. But what will become a judicial issue will depend on how the COMELEC will decide
on this. All right, Attorney Theodore Te, sir, thank you so much for your time and take care.